So we're looking at Federal Rule of Evidence 608, which provides that anytime someone testifies as a witness, you can bring in another witness to say that this person has bad character for truth telling, that this person is a liar. You can always do that. The person who comes in to offer that statement is testifying only to that person's opinion. Now, in our first case that we're looking at, in the Michael case, we're looking at the other half of this rule. When a person's integrity or character for truth-telling has been attacked, then the person who's offered the witness can now bring in another witness to talk about the person's character for truthfulness. So if your witness is attacked for truth-telling, if your witness is attacked as being a liar, then you can bring in another witness to say, no, this person's a straight shooter. This person is a truth teller. Now, regardless of whether you're bringing in a witness to say this person's a liar or bringing in a witness to say this person is a truth teller after your witness has been attacked, the witness you bring in, either for truthfulness or non-truthfulness, that person can only testify in the form of an opinion. This person's a liar. This person is a truth teller. Now, in cross-examination of that witness, much like in cross-examination of a character witness who offers an opinion of a person's honesty or a person's law-abidingness or a person's habit of nonviolence, in every one of those instances, the person cross-examining that character witness can reference specific details that undermine that person's story. So just like with character evidence, you can cross-examine a person on details, but you cannot bring in those details in order to prop up someone's truthfulness or non-truthfulness. So in Michael versus State, the question we're asking is, when can you bring in the witness on truthfulness? When can you bring in a witness to say, this previous witness that you just heard from, I've known this person for 20 years, he or she is an honest person. When can you do that? Because the rules only allow it when the witness's character for truth-telling has been attacked. So in Michael versus State, we look at the fact that prior to the Federal Rules of Evidence, a lot of jurisdictions said, whenever a person has been cross-examined, you can bring in such a witness. But the Federal Rules of Evidence and the interpretation of those rules has been to the contrary, that mere cross-examination about a prior inconsistent statement is not enough to allow the witness to be rehabilitated with another witness who says this person is a truth teller. So in Michael versus State, the court says, look, there are 5 kinds of cross-examination. There are the kinds that go to the specifics of the statement. That is, you previously said something different, or someone else said something different about this occurrence. Those 2 go to the heart of the story you're telling, not to your general character to accurately report what you've seen. There are then 3 non-specific types of cross-examination. Those that show your bias, that you would prefer a certain outcome in this case. There are those that show your perception is poor, your eyesight is bad, your memory is bad. And then there are those that go to your generic truth-telling, that you are, in fact, a liar, that you file false tax returns, you lied on a bank application, those things that show you generally have bad character for truth-telling. So of all the types of cross-examination, it's only that final category, that category that says that you are not a truth teller, that allows for a witness to come in and testify, yes, this person is an honest person. This person has a record or reputation for honesty in the community, or more specifically and more correctly, this person, in my opinion, is a truth teller based on knowing this person in the community for 20 years. So what does it mean to have been attacked? That's the question, Michael. When has your truth-telling been attacked in that final category? Could mere cross-examination by prior inconsistent statement ever rise to the level of showing that you generally are not a truth teller? You start bringing in other instances of a person not telling the truth. You filed false tax returns. You lied on bank applications. Those are definitely things that go to your character for not telling the truth. But what about cross-examination by mere prior inconsistent statements? And the court says in that instance, not necessarily. Mere inconsistent statements could merely mean that your memory is bad, that at one point you thought these were the facts and now you think these other facts are true, and one of the two is correct, one of the two is false, but that's not saying you generically lie. That's saying that for whatever reason you've got two stories, one of which is true and one of which is not. But the court says that if the cross-examination goes into a number of prior inconsistent statements, if the overarching theme of a multitude of cross-examination, a multitude of prior inconsistent statements, if that overarching theme is this person just is not being square with you, that the nature of even prior inconsistent statements could rise to the level of an accusation of not having a good character for the truth. It'll be determined on a case-by-case basis, but in Michael, the court looks to that Cruz case where they say, by the time the prosecution had finished inquiring about all these prior inconsistent statements to multiple people, the jury was left with the impression that this person was simply a liar and not had been mistaken in making this different statement now on the stand. And so the court says it's a case-by-case inquiry, but what you have to find in order to allow rehabilitation by offering a witness to a person's truthfulness is to show that the cross-examination has risen to the level or to the point that what we are effectively saying is that you are not generically a truth teller, not merely that you've gotten it wrong on this particular occasion, that you misremembered it, that you misstated it, whatever reason, that the cross-examination has to rise to the level of effectively a claim that you are not a truth teller generally.